For most people to make a valid will in England and Wales, they must be 18 or over. The requirements to make a valid will are set out in Section 9 of the Wills Act 1837, which provides that a will must be in writing and signed by the person making it or by some other person in their presence and at their direction. The person must intend by their signature to make a will, and that person's signature must be made or acknowledged in the presence of 2 or more independent witnesses present at the same time. And each witness must then either sign the will or acknowledge their signature in the presence of the person making the will. The will can be handwritten by pen or pencil or typed, but if the will is written in both pen and pencil, the law presumes, but subject to evidence to the contrary, that the part in pencil isn't meant to be included. The law goes to great lengths to ensure a person's wishes are put into effect. For instance, in the 1903 case of Whiting and Turner, a will written on an eggshell was held to be valid. A person's signature doesn't actually need to be their usual signature, provided it can be shown that they intended it to be a signature for their will. In fact, in the case of Ree Finn, an inky thumbprint did the job. For a will to be valid, both witnesses must actually see the person signing or acknowledging their signature. Each of them must, whether in the presence of each other or not, sign the will in the presence of the testator. During the coronavirus pandemic, the government relaxed its laws to allow wills to be witnessed remotely via video. Where a witness to a will is also a beneficiary under the will, or a spouse or civil partner of a beneficiary, then while the will might remain valid, any gift to that person will fail. There are some exceptions to the formal rules which apply in the cases of soldiers and those in military service who can be under 18 and whose wills needn't be in writing. A good example of this was the case of re-estate of Ashley Edwards Servos Gavin, in which a ship's radio officer had told his cousin that in the event of his death he wanted his estate to pass to his aunt. There were overwhelming examples of evidence to support that these conversations took place, and so the court held that that oral will was valid. For everyone else though, wills have to meet the strict formal requirements.